Shopify is a platform built for growth, whether you're just starting out or already running a thriving business. From managing inventory to creating a seamless checkout experience, Shopify is designed to handle it all. And it doesn't stop there. Shopify helps you sell everywhere your customers are, online or in person. It's the ultimate tool for turning big dreams into big wins. Sign up for your $1 per month trial period at shopify.com/OPP.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my wavering co-host, Brett.
Ooh, wavering. That's good. You really pulled that one.
Pulled that one out of nowhere. You know why? Because we're talking about some, perhaps, appeal waivers today. You see what I did there? There's a pun on words.
Yes.
I've always been told that if you have to explain your jokes, they're not funny.
It's true. Unless you're intentionally being funny and explaining them. So maybe it was funny. I don't know. We'll let the people decide. But yeah, there's been a lot that's happened in true crime lately. We've got a couple updates we want to discuss. We try and make legal briefs educational, and we're going to talk about what I thought was one of the most boring topics in the law, appellate waivers, but became super interesting and controversial in the Bryan Kohberger case. You had a lot of newly minted attorneys on Twitter and Reddit in various Facebook groups who were explaining how appellate waivers don't actually mean anything, and this is all a huge trick or conspiracy by Bryan Kohberger. And so we thought, hey, let's talk about what the law actually is. Boring, but whatever. That's what you pay for.
That's right. Well, those of you who don't know what we're talking about, Bryan Kohberger, of course, was indicted for the quadruple murder in Moscow, Idaho. And it was going to be a very highly anticipated trial that was going to start right about now. But as more than 92% of criminal cases do in this country, he pleaded guilty to all 4 murders rather than go to trial. And part of that plea was a plea agreement. Now, we've always said this. You can always plead guilty when you are the defendant. You are not always entitled to a plea agreement. A plea agreement usually gives you some chits or something that you're trading in for saying, I am guilty, so we don't have to spend all of the resources of the court, all the resources of the taxpayers to go to trial. But you're not entitled to it. Now, because you are getting something in return, whether it's a recommendation to a certain type of sentence, whether it's to avoid the death penalty, you usually give up certain rights as well. And one of those rights, of course, is waiving your right to appeal. So if you go to trial, we've seen this in other cases, and there's a jury verdict, the criminal defendant has the right to appeal it, and they almost always do. And those appeals can go on and on and on and on. You can imagine if a trial costs that much money, how much does an appeal for years after, 10, 20, 30 years, sometimes when you're talking about death penalty cases, is an immense drain of resources on the prosecutor's office and also on the courts. So it's not surprising then that when you are given a plea deal that is not something you're entitled to, one of the things you give up in exchange for that plea deal is your right to appeal your conviction.
Yeah, and it's actually interesting because just by virtue of pleading guilty, you give up a lot. Just by pleading guilty, even if it's a open plea or a straight plea, whatever you want to call it, a blind plea, there's lots of different terms for it, but essentially pleading guilty without the benefit of a plea agreement. Once you do that, you actually waive a large number of issues. So typically you waive non-jurisdictional issues. So for instance, in the Kohberger case, he had filed a motion to suppress, and that motion to suppress was denied. By pleading guilty, he waived that issue. So even if he could file an appeal, he couldn't appeal that issue. It's waived. The only way to preserve that is actually to have an agreement. And you have to get together with the government and say, hey, I'm going to plead guilty, but I want to preserve this issue. We had that suppression issue. It really was the entire case. This happens a lot. It was the entire case. If I had won it, I would have won the case. You won it. Now you're going to win the case. let me preserve that for appeal. We won't go through the rigmarole of a trial we don't need that we all know I'm going to lose, but this way I can do that. And a lot of times that's what your plea agreement will say. You waive everything except you expressly reserve the right to appeal the suppression hearing. So a lot of issues are just waived by virtue of pleading. But the issues that aren't waived, things like your sentence, for instance, fairness of your sentence, like all the sort of post-plea stuff, frankly, that's not waived by a plea unless you have a plea agreement that does it. And in this case, obviously, there was a waiver, and we talked about how this was really good because this meant finality for the families, and it meant that they weren't going to have to deal with appeals from now until the end of time. Well, after that was entered, there was a hearing on the gag order that was in this case and whether or not it should be lifted. And the judge said, well, hey, I'm going to lift the gag order, but I'm going to leave it in place over certain things until the appeals period has passed. Because obviously, even though he's waiving his appeals, there could still be appeals in this case. And people lost their minds. They were like, what is he talking about? We've been hoodwinked. This is all a scam. He's going to be appealing to the end of time. This was a disaster. The family's got nothing, et cetera, et cetera. TikTok was going crazy. People on Twitter were losing their mind, and all the various Idaho Facebook pages. And there were people who were like, not only is he going to appeal, he's going to withdraw his plea. This is just a delaying tactic so that he can, they didn't grant his motion to continue his trial. So this is the way he's doing it. He's going to say he's going to plead guilty, and then he's going to withdraw it. And then they'll have to delay his trial and all this other stuff. And I actually put out a short video, The Law is Not Stupid, as we often tell you guys, sort of explain that. But we decided we would go through some of these issues in detail. In particular, this issue, particularly, he has now been sentenced. So anybody who thought he was going to withdraw his plea, that ship has sailed. But nevertheless, he has 42 days after his sentence is imposed to file an appeal. That clock is ticking. And the question I think a lot of people were concerned about, is he now going to appeal as if this whole plea agreement didn't even exist? And isn't that going to put the family through the same sort of turmoil that they were trying to avoid? And this all stems from an Idaho case. There's a reason that the judge was particularly attuned to this, because there's a case called Garza v. Idaho, which addresses this very issue.
Isn't that always helpful when you do have a case on point and out of the same state, shall we say here? So Garza versus Idaho was a Supreme Court decision, and the holding in it is actually very straightforward. It says that if a defendant tells his lawyer to file an appeal and that lawyer doesn't do so, that itself is ineffective assistance of counsel, even if the appeal is otherwise barred by an appeal waiver. So that's really simple. So even if, as in this case, Bryan Kohberger has waived his right to an appeal, if he tells his lawyer, file an appeal, and the lawyer doesn't file an appeal, that's an effective assistance of counsel. So you might be thinking, what? Why? This seems like a complete waste of time. Well, there were dissents in this opinion. So Sotomayor wrote the opinion, and she was joined by Justice Roberts, Ginsburg, Breyer, Kagan, and Kavanaugh. And in the dissent were Thomas, Gorsuch, and Alito. So basically in this case, the facts in this case were that the defendant, Garza, pleaded guilty, and like a lot of the waivers that we've just talked about, he had an appellate waiver. Now, even though he had waived his right to an appeal, and by the way, if you've ever sat through a change of plea hearing, the judge goes through a long list of questions, and they are rote questions for a reason, because you have to hit all of these questions to make sure the defendant knowingly is giving up all these rights. And one of the questions that the judge will ask the defendant who's pleading guilty is, do you know that you are now giving up your rights to appeal? And the judge asked that person, do you understand what that means? So in this case, Garza pleads guilty, appeal waiver. Nonetheless, he says to his lawyer, I want to appeal. And his lawyer says, hey, dummy, you waived that right. Remember, the judge told you about it. We talked about it. You can't waive. There's an appeal waiver. And the lawyer said, I'm not going to file a frivolous appeal. Now, Garza gets a new lawyer and he appeals. The Idaho Supreme Court says in order to appeal, you need to show some sort of prejudice. In other words, you need to show that you might actually have a chance to succeed on that appeal. And that was eminently reasonable. So it's no surprise that the Supreme Court went the other way.
And there's actually a rule, and there's rules of professional conduct, and there are rules in the various states and federal procedure rules that say a lawyer shouldn't file a frivolous appeal. That's, sort of on you to really think about, is this a waste of the court's time? Is it a waste of resources? And if it is, you as a lawyer have a duty not to do it.
It's one of the things that we're called to do, right? Like, just to give you an example, both in the government and in private practice, I've had clients, when it's in the government, it's like a federal agency or something, and they're really heated about an issue. The other side, they're lobbing defamatory statements at us. They're saying we are liars and cheaters and et cetera, et cetera. And so many times I have heard from a client, public or private, file a sanctions motion. Get that attorney sanctioned for that. And almost 100% of the time, I'm like, okay, it's baseless, it's frivolous. I'm not going to do that. And the reason we don't do that is I am called as an officer of the court to make that independent assessment so that I'm not just sitting here filing frivolous motions and clogging up and tying up, by the way, taxpayer dollars.
Yeah. And it's funny. This lawyer is doing the thing that the law requires. Garza has said, hey, I want to file this appeal. And they say, look, you can't. That agreement you signed says you can't appeal. As Alice said, you were there for all this. What's going on? And then Garza says, the time passes, he loses his right to appeal, he gets this new lawyer, and he says, that person was ineffective. My ineffective counsel, constitutionally ineffective. Think about this. So bad, they denied me my constitutionally guaranteed right to an attorney because they wouldn't file a frivolous appeal. And remember, when we do ineffective assistance of counsel, there are two prongs. There's, were you deficient in your performance, and was there prejudice? And prejudice is always something you consider. So the Idaho Supreme Court's like, hey guys, number one, seems like if you're not filing a frivolous appeal, that's actually a good thing. But number two, certainly you have to show some prejudice here. You got to show that the thing you would appeal, you actually had a chance to succeed at. Like, that wasn't covered by the appeal waiver, or that, really went to the heart of your plea agreement, and the whole plea agreement's invalid. You were tortured into this something, right? Makes total sense. Goes to the Supreme Court. Supreme Court says, nope, that attorney who didn't file a frivolous appeal was constitutionally deficient in their performance, and prejudice is assumed because he had a right to appeal. He told them to appeal. They didn't do it. Therefore, he lost his right to appeal, and that's the prejudice. He lost a right that, you may recall, he has bargained away. So the Supreme Court, in this opinion, tries to explain why this makes sense to them. And one thing they say is, hey, an appeal waiver doesn't bar all appeals. And that's true. It doesn't. And you might wonder why that wouldn't be covered by the prejudiced argument of the Idaho Supreme Court. And they never really grapple with that question. The best they can come up with is that they sort of divide the defendant and the attorney. And they say, hey, defendants don't really know the law. They just want to appeal. And they may not even know, really, what they want to appeal. They just want to appeal. And that's going to be up to the appellate attorney to determine, after the notice is filed, whether or not there is some sort of valid argument they could make. And look, this seems a little strange, but there's some force to it. In the federal system, for instance, you have 14 days to appeal. You used to only have 7. But they expanded it to 14 days. So you have 14 days after your sentence to file a notice of appeal. And if you don't do that, your appeal is waived. You file an appeal then, I'm filing a motion to dismiss and saying, hey, he missed the deadline. You need to dismiss this. Half the time, the courts let him file it anyways. But nevertheless, it is a rule. They're supposed to file it in 42 days in Idaho. That's not a lot of time. It's not a lot of time to figure out a legal theory for why you want to appeal. And so the Supreme Court is essentially saying to make them have a legal theory at the time of the appeal, it's too burdensome and it's too difficult to manage. So better to just say, if they say they want to file an appeal, they get to file an appeal, and we'll just deal with it on the back end. And this is really important for the Kohberger thing and everything else. And here's how they explain that. We are confident that courts can continue to deal efficiently with such cases via summary dispositions and the procedures outlined in Anders. So essentially they're saying, hey, man wants to file an appeal. He gets to file an appeal. But that doesn't mean the waiver is worthless. The waiver becomes powerful in the substance of the appeal. So essentially, you want to file an appeal? That's fine. Oh, you filed your appeal now? Well, guess what? We're summarily dismissing your appeal because you waived your right to appeal. And your attorney, the one who said this is frivolous, can file what's called an Anders brief. And an Anders brief is a brief where the attorney says, hey, I didn't want to do this. My idiot client wanted to do it. And guess what? He doesn't have an argument under the sun that could possibly succeed. So I'm filing this brief saying, this is a frivolous appeal. You should dismiss it, right? So the Supreme Court is really like, you just got to jump through this hoop. It's just required to jump through it, but it's purely procedural. They'll file the appeal and it'll be dismissed.
So this purely procedural thing, just so you know, takes a lot of time for an attorney. Anders briefs are not so simple as like a line that says this is a frivolous appeal. You actually like go through the arguments that your client wants to make and say why they are frivolous, right? So Anders briefs, they're not nothing. And I think it's funny how it's like, I'm confident that the courts can deal with it on the back end. Just so you know, across the nation right now, there are multiple courts in declared judicial emergencies. And what that means is that there are vacancies on the court because there's like the rule of 80 or something like that. Judges can retire at a certain time. It's a very tiring job. You can imagine if you can retire, why not retire, right? And so when you retire, guess what? It's not like you can go online and just
get your full pay, by the way.
You keep getting your full pay for the rest of your life, which is a lot of money from the public fisc. That's another thing for another day. But usually when someone vacates a position, what do? Just hire somebody else. Except when it's the federal bench, what has to happen? 3 branches of government. The executive has to nominate. There has to be a whole confirmation hearing and a vote.
No guarantee that's going to work out.
No guarantee. And that's why actually there are a lot of judicial emergencies across the nation, because you can imagine in a smaller district, our district is only 3 judges for an entire district of a lot of cases that are going on. Criminal is just one side. There's civil, there's bankruptcy, there's et cetera, right? And so if you lose just one, you're down 1/3 capacity. And that is in courts across the nation. And you have all these actually frivolous briefs being filed by people in prison, writing for themselves as attorneys who just write briefs all day long because that's all they do. And so both Brett and I have served as law clerks, both on the appellate courts and on the district courts, and have seen this in practice. These types of briefs take up an inordinate amount of time. It is not a stamp where you can be like, frivolous, denied.
And there's 2 things about an Anders brief, which is kind of funny. Number one, relying on an Anders brief. If a lawyer files an Anders brief, the way that works is it is then incumbent on the court to review the entire record and determine whether or not they think there's a viable issue. If they do, they then file something instructing the attorney like, hey, we actually think maybe you have this issue, so go file a brief on that. So in a lot of ways, it is more work. Second point on Anders briefs, a lot of attorneys would rather just file
the brief
something.
And lose.
Yes, just something than doing an Anders brief because it's too much work. So thinking an Anders brief is going to take care of this. Now the summary dispositions, maybe, though I'll tell you, when I took over my job, I'm the appellate chief in my job, as you guys know. So we have these appeal waivers. Well, for years, we didn't enforce it. If you filed an appeal, well, we just went ahead and did the appeal, even though it's barred by the plea agreement. So then I took over the job, and I'm lazy. So I was like, no. Like, we're enforcing these things. So I'm filing motions to dismiss every time somebody does one of these. And the court, it took them a while. Like at first, they denied a couple, and a couple they did what they called carried with the case, which means they decide the whole case and decide that issue, which doesn't do you any good. Had an oral argument on one, and the judge was like, why are we having an oral argument?
I remember that oral argument. Counsel, why are we here? Like, I don't know, Judge. Why are we here?
But now, and then they started granting them, but they'd write these long opinions, and now they grant them with like a paragraph. So I like to think that was on me. But anyways, so just this notion, though, from the Supreme Court that, oh, no, it's easy, they'll handle it, no big deal, is not necessarily true in practice.
And a lot of you, if not only the practice part, if you're like, then what are we talking about here? Like, even a toddler understands this whole notion. I give you a lollipop, you give me something else. You can't now ask for the other thing back, right? That's exactly what is happening
appeal
in
to
Garza,
dad.
Idaho. Exactly. Appeal to dad. Yeah. Well, dad is the Supreme Court here, apparently. So the dissent essentially says, why not just have a rule that says you can only appeal if you identify a claim not covered by the agreement? You argue the plea was involuntary, or you say that the government breached the agreement, something like that. And indeed, that's a good question, because Garza specifically wanted to appeal his sentence. Precisely the right he'd bargained away, right? The reason he pled guilty was for his sentence. Now, the court was essentially forcing an attorney to file a frivolous appeal to avoid being called constitutionally ineffective, which is really a rock and a hard place, because you have a duty to the court to not file these frivolous briefs, and then you're being called constitutionally deficient, which is like, I don't want that mark, on my forehead for the rest of my life. So in the end, as many Supreme Court cases go, while there's all this ink spilled on essentially a Ferris wheel of circular going nowhere, this whole case was a huge waste of time, practically. Garza sent down to the district court. He won at the Supreme Court, right? You get to file your appeal. And he says, aha, I get to file a notice of appeal. And guess what happened? His appeal was promptly dismissed as barred by his appeal waiver. I'm not kidding. This is like Shakespearean in the way that it happened. And by the way, I'm pretty sure the Supreme Court knew that's exactly what was going to happen.
And in fact, the Supreme Court would say, see? Like the majority would be like, see?
So easy.
It worked out exactly like we said it would.
You were able to dismiss it promptly as we said.
Yeah. And the way this works is I've had this happen. And I'll tell you, to this day, still, attorneys are like, we'll get 2255s where somebody says, hey, I wanted to file an appeal. I told my attorney to file an appeal. He didn't do it. And I'll pull up the thing and look at it, and there's the plea agreement, there's the waiver. And I'll call the attorney. This attorney-client privilege is waived when you say your attorney's ineffective. I call up the attorney. I'm like, hey, one of your clients is saying that they told you to file an appeal and you wouldn't do it. And they're like, well, yeah, I didn't do it. They waived their right to appeal. Well, I'm not going to file. That's completely frivolous. I don't do that. And I'm like, well,
Garza v. Idaho, man.
Yeah. The thing about that is you have to do it. And so the way it works when this happens, it's just so ridiculous. The whole thing is ridiculous. So you have a habeas petition, right? Saying that your sentence is unconstitutional because your right to file your appeal was denied. So you have this, the court grants your habeas petition, finds the attorney ineffective, vacates your conviction, reinstates your conviction, reinstates the same sentence you had before, and then tells you have 14 days from this order to file an appeal. Half the time they don't file appeals, but you file the appeal and then it gets dismissed. It's just like this ridiculous.
It is a complete rigmarole, but practically, no, he does not have a right to appeal in the sense that it will go nowhere. He can file the appeal unless he has some sort of involuntary plea. This episode is brought to you by Progressive Insurance. You choose to hit play on this podcast today. Smart choice. Progressive loves to help people make smart choices. That's why they offer a tool called Auto Quote Explorer that allows you to compare your Progressive car insurance quote with rates from other companies. So you save time on the research and can enjoy savings when you choose the best rate for you.
Give it a try after this episode at Progressive.com. Progressive Casualty Insurance Company and Affiliates, not available in all states or situations. Prices vary based on how you buy.
This is your before and after story. Southeastern College can help you prepare for a secure and fulfilling career in the growing healthcare field. We offer a wide range of careers to choose from. So whether you want to be a medical assistant, medical billing and coding specialist, nurse, surgical technologist, or another healthcare career, we've got you covered. Become a vital part of a healthcare team and make a real difference. Southeastern College, your future is bright. Visit sec.edu to get started.
Shopify's point-of-sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.
And the way you could have done this, so the Supreme Court has not said it, but it's essentially believed that you can't bargain away ineffective assistance of counsel, Right. It's like the one thing you can't waive, that and government misconduct. So you can waive everything else, but you always have the right to say your counsel was ineffective. So Bryan Kohberger, he may eventually file one of those. He'll lose. It's frivolous. No big deal. But the simple way to have done this by the court would have been to say the appropriate procedure when someone says they told their attorney to file an appeal and they didn't do it is to challenge that in habeas and to say, in habeas, the reason this was prejudicial is because I did have this argument that I could have made. This solves the timing problem because you have a year from when your conviction becomes final to file a habeas petition. So this whole thing about, well, they only have 14 days, or they only have 42 days, like how could they come up with the issue? Very easily solved. They can put that in the habeas petition and say, this is why I was prejudiced, because I had this argument. And my attorney should have realized that, and they should have taken care of this. That would have solved this whole problem without this bizarre dance, which, as Alice said, only the kind of thing that a bunch of very smart people who've never really practiced law, because none of them have in any sort of real court. They're all in the Supreme Court. You know, Justice Kagan was a law professor, was dean of the law school. She was in Solicitor General. Solicitor General is not dealing with like what a district court's dealing with on plea agreements, right? Brilliant person. This is not something she's done before.
Right? Like not boots on the ground.
Gorsuch, you know, he was at DOJ. He tried one case, and you would think that case was like, it was like the OJ trial. You know, if he's listening, love you, but like, you know, it's like he acts like it was the biggest trial ever, right? And then he was on the appellate court, and now he's on the court. Now he got this right. He dissented. But nevertheless, like, this is just so formalistic, and it's so ignorant of the way things
now
actually
here's the
work.
funny thing, the author of this opinion is probably the
That's
only
true.
one of them who practiced. She was an AUSA. She
That's
was a
true.
prosecutor. So this is actually not the
That is
first time
ironic.
that the one prosecutor on the court, she didn't practice for
And she
that
was a
long,
district
but
court judge.
she was a district court judge, but again, you know, what have you. That it is ironic. Maybe that's why they made her write it. They're like,
That actually makes
can
sense.
explain
I bet that's exactly why
it.
they made
They're
her
like,
write
you
it.
get it? You've been there? And she's like, I have been there. I know what I'm
she is.
talking about.
Like,
Yeah.
if you look at the people who wrote this, you got her, Roberts, who never did anything. I mean, like, no offense to the Chief
let's
Justice.
not piss off
but,
the entire court while we're at this.
I mean, Ginsburg was a litigator, but not, I don't think she was ever a criminal.
So I was going to
litigator.
say civil rights.
Yeah. Civil rights and civil stuff.
Brian
I don't
was a
actually know what
professor.
Breyer did.
Professor? I don't know. He talks
Was he
like a professor. Wasn't he a
Yeah, that makes
professor?
sense. Yeah.
He
So
talks
anyway,
like a professor.
and that's just the way it is, and that's fine, and the courts deal with it. But then you end up with all these people who knew that 6 years later, all these people are going to lose their minds because of this case and think, wow, now that this case has come out, Bryan Kohberger, he's going to be appealing everything. And this is just, it's a complete waste of time.
Just maybe, if he appeals, it'll go all the way up to the Supreme
they could
Court. And
reverse it.
Sotomayor will be like, you know what? That was an oopsie. Let's revisit this. Stare decisis, smari decisis. Let's revisit this because practically it makes no sense.
Let's see. You got Ginsburg's been replaced by Barrett, and Breyer has been replaced by Jackson. So
It's not going to.
maybe they could flip
I don't think it'll flip.
5-4. Yeah.
I don't think so.
Yeah. Anyway, so that's what happened in this case. And the long and the short of it is, I don't think Kohberger will actually appeal.
No.
But if he does, it will be dealt with.
Swiftly, summarily, and promptly as the Supreme Court wishes.
Exactly. And I'm sure his attorney will file an Anders brief, and that'll be the end of it. So,
And maybe
this
in
is
that
not-
Anders brief, he'll say why he did it. I'm just kidding,
There you
guys.
go. Maybe.
I'm just kidding, guys. Here's the thing. Remember, motive, not part of the charge. He could have gone to trial. A lot of you also, we're just addressing other things that you guys have brought up. You said, now we'll never know why he did it. We were never going to know why he did it, even if he went to trial. He was not going to take the stand, and he was not going to say why he did it. So that's never part of the case. We always try to explain the motive because storytelling is important to understand how something so horrendous can happen. But he didn't need to say it during his plea. It's not an element that needed to be proved factually, and he was never going to take the stand to say it. Even if this case went to trial, we would not know more in terms of why he did it.
And while we're talking about this, So at sentencing, he declined to even make a statement. So he didn't even make a statement at sentencing.
And just note, a lot of people do make a statement at sentencing, and it can be something as innocuous as, I love my mom. Like, if they don't want to say guilt or anything.
I want to apologize to my family.
I want to say sorry to my family. They don't even have to necessarily apologize to the victims. Most times they'll say something before they go away forever. I mean, he was not going to speak ever. I think we both kind of said that we were never going to know what was in his mind. That was part of his thrill.
I think eventually he'll give some sort of interview where he'll give some explanation, which will probably be false. You know, it's like the Chris Watts case. Now, he's lied like 15 times about what happened that day, right? You're never going to know exactly what happened. I mean, you will if you just use your common sense, but you're not going to know from him what happened. So in the Kohberger thing, and one other thing to mention about that. So at the sentencing, great victim impact statements. People have asked questions about that. Number one, if you remember our coverage of the Purvis Payne case, that case went to the Supreme Court. And that was actually the case where the Supreme Court said victims get to make an impact statement. Because there was some question about whether or not that was too prejudicial. And the court was like, look, guilt's over. Guilt's been decided. This is just statements to the judge. They should be able to make those statements if they want to. And so now that's one of the few rights, frankly, that victims had. The victims let him have it. People asked, what are the limitations? As we've said before, the closest thing we have to a imperial monarch in modern society is the captain of a ship and the trial judge. And the trial judge, he commands his courtroom. So the judge can let them do whatever they want. Use profanity, yell, directed at the defendant, whatever they want to do. If the judge is happy with that, he can do that. Some judges don't do that. They'll say, for instance, direct your comments to the court. So you can say whatever you want, but direct it to the court. Don't direct it to the defendant. Some judges, profanity is a huge no-no. You can't do that. And it really just depends. I mean, in this case, you have a quadruple murder. You have the family of the victims. This is their one chance. They're already, or some of them at least, are upset that this wasn't a death penalty case. The judge recognized that. And so he gave them full reign. Perfectly able to do that. Not prejudicial in any way to the defendant. There's no appeal issue there. You don't have to worry about that. And it's just really up to the judge. And frankly, one thing we often talk about, and I think it's important to remember, and I always want to remind people of this, because we're a very sort of technocratic society, right? We got this whole like everything's science and reason based, and that's great. But trials are very much, and the judicial system is a replacement for a much more visceral system where justice was very personal. And we've decided we're not going to do that because of all the negative externalities of having that kind of system. So we're replacing that with this very sort of staid, official thing. But emotion still plays a role, particularly in sentencing. So having that sort of emotional outburst from the victims, I think is totally appropriate, because that's the one opportunity they're going to have to direct anything at the defendant, at the person who killed their loved ones. So I'm of the opinion, if the victim wants to speak, they should be able to say whatever they want. That's my position. Some people disagree on that, but it's basically what the Supreme Court said as well.
And that's my position as well, because basically we don't want mob justice, right? In the sense that, like, we don't give victims free reign to, like, just go shoot to death. So, well, in some jurisdictions you do. Sometimes in Texas that happens, but that's not the justice system. But because we don't allow them to do that, which honestly a lot of other societies in history have allowed, right? Like, you kill my daughter, I get to come and kill you then, right? An eye for an eye. But because we have moved away from that sort of swift justice, shall we say, I am fine with all of the rage that the victims' families want to direct in the court of law, because I do think that is still way more decorum than, you know, the eye for an eye, for example.
So I think, frankly, that's probably enough Bryan Kohberger for the rest of time. And look, I know it upsets some people, but the fact of the matter is there's going to be documentaries about him. He's going to be studied. You know, he's going to be talked about. That's just the way it is. And I get it, sort of the notion of we should never mention his name again. I wish that were the case, but it's not going to be the case. It's just like Ted Bundy or, you know, any of these guys who become notorious. And I know that's what he wants, but he can enjoy that from prison for the rest of his life, hopefully. So that's Bryan Kohberger. We also wanted to discuss briefly Ellen Greenberg. So Ellen Greenberg is one of those cases that is close to our hearts because We feel as though an injustice was done here, not because we are necessarily sure that she was murdered, but because we are absolutely certain that she never got the investigation she deserved. That, if this was suicide, it was never determined by an appropriate investigation. And if this was murder, it certainly was never investigated in any kind of appropriate way. And as most of you may recall, there was a settlement. Her family, her parents have been fighting for years for an investigation into their daughter's murder, which I'm sorry, we're talking about society and how we've replaced this whole vindictive system. Well, part of that bargain is I give up my right to kill the person who killed my child for you to be responsible for investigating what happened, determining whether or not it was a murder, and prosecuting it if it was. And in that case, the state completely failed to keep their side of the bargain. So her family has been fighting for years for that kind of investigation. There was a lawsuit, and on the eve of trial, when it looked like things were going to go pretty bad for the city of Philadelphia, they settled. And part of that agreement was there would be an actual, legitimate investigation into this. And my concern at the time was I didn't buy it, frankly. I just didn't know that if the city of Philadelphia, particularly given the position of the governor of Pennsylvania, which apparently is that the parents are lashing out in grief, if they would ever actually conduct an investigation. And unfortunately, it seems as though in the months since that settlement, no investigation has been done. So now the family is back in court trying to enforce that settlement agreement.
And that's really hard. That's a really hard thing to enforce because, and we said this back then, what is a proper investigation? Honestly, if the city were smart, they would absolutely open it, make a bunch of press about it, and do nothing, right?
They're not even that smart.
Right, because then there's nothing to point to in the court of law to say of course we did everything we could. What can we do? It's years old. Everything's stale. We did all the investigation. It was all cleaned, literally cleaned by a professional company days after she was found dead. So there's all the evidence is gone. Sure, we'll go test all these things. Oh, look, everything came back inconclusive. We got nothing, right? It's actually pretty easy to make it look like you're doing a lot and not do a lot. And that's actually what I thought they were going to do, is to make all this hullabaloo around it and make all these press releases we found, 6 hairs downstairs in the lobby that have nothing to do with the case. We're going to send them all out for testing. Oh my gosh, all 6
Othram's
hairs.
on the case.
Yeah, Othram's on the case. All 6 happen to be just security guards that work downstairs. Wow, rats. Back to square one. You know what? Square one is a clean apartment that was cleaned decades ago. We got nothing else. We did everything we can. We spent so much attention and man hours on this. We're going to have to close it now. This is all we have. That's what I thought they were going to do, which is horrible because I don't think that's an honest investigation, but it doesn't seem like they're even doing that.
And look, how do you do this? Some people have asked that question. So what does it even mean? Obviously, the city of Philadelphia cannot conduct this investigation, in my opinion. Because let's say that everybody's new. Just imagine for a second, everybody's new, they're not connected to this case, and they're 100% committed to finding the truth. And they conduct the best investigation ever, and they reach the conclusion that this is a suicide. Who would believe them? No one. We talk about the difference between a conflict of interest and the appearance of a conflict of interest and how the appearance can be enough. Well, there's an appearance here. They can't do it. I don't think a neighboring jurisdiction can do it because there's a natural inclination to help out your friends in Philadelphia. I'm sure the good police in Philadelphia investigated this thoroughly. So when we look into this, remember that, right? You can imagine that. Now, look, there are ways this has been done. I mean, think of I think it was the Mitchell report in baseball, right? Baseball says, hey, look into the steroid thing and determine what happened. Or, in Penn State type situation, investigate what happened and give us the truth. You could outsource it to someone, but that's going to take money, a lot of money. When I was in private practice working for a big firm, one of the things we did was a monitoring. And so essentially you'd have a big company who would have a violation and they would say, look, rather than getting a bunch of trouble for this, we will pay a whole bunch of money to this law firm to do an independent monitorship of our company to evaluate everything we've done, to tell us what's wrong, to write a huge report, and to fix it. And then whatever the sort of prosecuting authority would review that and say, yeah, this is legit, right? And that's a huge source of money for law firms.
I was going to say, people hire me to do that, right? Because I was a former prosecutor and they're like, hey, IRS hasn't investigated us yet. Can you take a look before they come? Like, what did we do wrong? And that is actually, you have like different governing boards that are different than, say, the CEO or something like that. The board, because they want to make sure that there's an independent check, are often the ones to do that, to hire an outside audit. That is a real audit. I mean, I do real audits. You shouldn't hire me if you don't want a real audit.
Yeah, and look, the city of Philadelphia, and probably the state of Pennsylvania at this point, because the governor was the AG who signed off on all this, so they have a real interest in this going away, and that's the problem. If they mess this up, they messed it up so badly at the beginning, it'll never be prosecuted. And I'm sorry, but that's just the truth. They have ruined this case. They've ruined it. They ruined it from the very beginning. Like, how do you prosecute this case ever, right? So they don't want to look into it because they're terrified that they're going to find out that they messed this up from the beginning. I mean, just imagine how the bad press they're going to get.
The investigation really is probably a self-audit, right?
Yeah. So they have that interest. Now, you might think, what about the FBI? So in the Karen Reed case, they were able to con the FBI and the U.S. Attorney's Office into investigating that case by hanging it on this claim of corruption in the police department, right? And that was pretty clever because that way you get the sort of federal investigation.
Civil rights,
exactly.
Angle, which is typically when you need an outside source to come in because the very core of the claim is it's so rotten from the inside. You can't root it out, but from on high.
Exactly. So, they're making that claim and that brings them in, and that ended up being very valuable for her because she gets the whole, whatever they were called, ARCA comes in, they do their reconstruction, they become a defense witness, et cetera, right? Could you get there with this? Maybe, but you really need someone who, number one, has an in with the feds and can make that claim, and a U.S. Attorney's Office / FBI office that is willing to do that. In Boston, they found a willing accomplice who already had a lot of doubts about the state troopers, the whole state police that had issues with them, and was kind of looking for another opportunity to investigate. I don't know if you have that in Philadelphia, though frankly you should, because Philadelphia has a long history of having these issues. So that's the other option. And I think you would need a hook like that to really get them involved. And the final option is the AG's office. Now, interestingly, I think the AG is a different party than the governor. I could be wrong about
right.
that. So that actually might be a way to do it. Like, you have sort of a political thing there, right? So maybe you have an AG.
Check, yeah.
Yeah, exactly. An AG who's more willing to go against the governor and the city of Philadelphia than someone else. But I mean, if this is left to the city of Philadelphia, it's never going to happen. And I'm afraid, honestly, when this happened, I was afraid they'd do exactly what you said. A cursory investigation where they didn't really look into anything just to check the box. Seems like they didn't even do that. So maybe that's a blessing. Maybe it's a blessing.
Because now it's so egregious that you almost need, now there can be some sort of claim like you are in so much violation, right? Because if you go through the motions, you can't really go into the intent. How are you judging the gradations of how good the investigation is? Maybe I'm just a really bad investigator. I didn't say I can't change who I am. That would be the defense to kind of the type of investigation I was outlining. But it might actually be better for Ellen Greenberg's parents for the complete lack of action. And if anything, it looks really bad on the city.
No, it absolutely does. And so we're going to have to see what happens. This is, a case that continues to, it has a lot of attention. And frankly, I hope it continues to get that. I hope it gets more. We need documentaries on this case. We need more podcasts talking about this case. Nancy Grace just wrote a book about the case. So that's great, because that's the only way we're going to get an investigation that the family deserves and that Ellen deserves. Because I don't know what happened. And I've said that, I don't even remember anymore what our conclusion was on the case, but so I'm not entirely sure what happened. I don't claim, I'm not one of these people who says this is absolutely a murder and a huge cover up. I don't know. But what I know for certain is that it was never properly investigated. It was never given the attention it should have been given. And a lot was done that was completely improper in this case. And that needs to be brought to light. And I hope it will be in a subsequent investigation.
I think people get a question. I mean, I know
sure,
let's
do a question.
but let's do a question.
Yeah, let's do a question. So that's our true crime news update.
You guys know that
this
if you
week.
leave a 5-star review for this podcast, Legal Briefs or Prosecutors Podcast, you can leave a question about anything. People are
Anything.
personal, has nothing to do with the law, has nothing to do with true crime, or it can. And we love answering your questions. And it's that was a lot of heavy news, Just
It was.
both cases are so sad for the victims and the victims' families. But while we're looking up a question, CrimeCon is around the corner, guys. Like, so around the corner. Hope to
So
see a lot
around
of
the
you guys
corner.
there.
I also want to note, because I guess it's public now, but we're going to be in a documentary coming out on August 5th about the Delphi case. Hope you guys will check that out. It should be, everyone's
We have not
favorite.
pre-screened it, so we
Nope.
don't actually know how much we're in it, if really much at all. I have
May
no
not be at
idea.
all.
We spoke for a long time, but it's very possible that they took 10 seconds of it, and that was it.
Yeah.
I have
We
no
know
idea.
everyone's favorite incompetent defense attorneys will be in it. So we'll see what they have to say for themselves. And I think it's going to be, in fairness, I think it's going to be sort of a comprehensive view of the case. I think they're going to talk about the conspiracy theories, and they're going to talk about sort of the, Richard Allen was framed and all that stuff. And that's fine,
That was a
as long
very
as-
big part of the case, like the life of the case, right?
Yeah.
That was not insignificant. People were prosecuted for perpetrating those torts of.
And they talked to us all day. So we gave them
they
plenty
did.
of information. We'll see.
Ultimately, the editors can choose what they put in.
Yeah, absolutely.
But anyways, I will not be watching it with any of you guys. I don't know. I don't know.
Okay.
Should we watch it?
Oh, absolutely.
Calling
We're
each
going to
other?
have a watch party.
I don't
of
know.
course.
That's too intense.
I watched
All
the
right,
trailer and I didn't look stupid in the trailer, so that's
You
all.
looked
that
great in the
matters.
trailer.
Do I look good or not?
You looked great. I looked so bad they didn't put me in the trailer.
Oh, whatever. I think didn't your voice was in it though, right?
Oh, I
In
haven't
the
listened to
trailer?
it
Okay.
with the sound on. I only looked at it. It's been a long day.
So this is a question from Lorelei Marie, who apparently is a bartender at Charlie's Kitchen, which, if that's the Charlie's Kitchen I'm thinking of, it's a bar in Cambridge, which I often would visit, not to drink, of course, because I would never do that, but just to hang out with friends. So maybe she served me. I don't know. But now we'll ask her question. So she says, I'd like to get involved in something like the Innocence Project or other similar organizations. How can I help without becoming a lawyer? I believe I could make it through law school, but at my age, not old, by the way, the time and monetary investment just doesn't seem worth it. I know I could possibly volunteer, but I'm looking for more than that.
Honestly, we are approached by so many people at CrimeCon who have an interest in a case and they really dive into it in research, compiling documents. A lot of these documents, especially if they're older cases, they exist, but you may have to go to the courthouse and do research. So if there's a case that grips you for whatever reason, the wrongful conviction angle, the innocence angle, whatever it is, if you become the preeminent expert of that case, that can lead to a lot. You can become a resource for podcasters, for journalists, for people making documentaries about it. And I don't know necessarily where that may lead, but in order to make a difference in general, a lot of people just read the headlines. Not a lot of people actually dig into the facts. And so if you are the person who compiles the information, which much of the information will likely be publicly available, just not easily accessible perhaps, and you can become the center point of information, which can do a lot of good for the true crime community, but also probably for that case.
Yeah, and I would just say, go to your local Innocence Project and ask, what do you need? Because maybe they have plenty of lawyers, but they don't have good legal assistance. They don't have people who can help them organize. They don't have people who can screen cases. Don't be afraid to volunteer. I know you say, I know I could volunteer, but volunteering is a great way to end up with a job. I've said this before. There's this thing that happened in the last 20 years or so where it was interns should always be paid and there shouldn't be volunteers and why are you working for free and all this stuff. They're taking advantage of you. And maybe they are. I don't know. But the fact of the matter is, if you show up at a place like this and you're really good and you offer a lot, at some point they're going to want to keep you. They're going to hire you.
They'll do fundraising to fund a position for
Exactly.
you. That will happen.
So go to your local Innocence Project. If they don't have anything, ask them, who are the attorneys you work with? Do you work with any other organizations, right? Get with those people. There's all sorts of things you can do. You just have to sort of be willing to ask, because I'll just tell you, so many people are working in these areas and nobody ever asks them those kind of questions. Nobody ever comes in and says, how can I help you? Right? So do it and see what happens. Like, you may very well find out they do have something where you would be good and you could provide a lot of opportunities. And next time I'm in Cambridge, I'm going to stop by Charlie's Kitchen. It's a great place. Great. If you're in Cambridge, if you're going to Harvard, or if you just live in Cambridge, old sort of established place, got a great outdoor bar. Wonderful. Check it out. Okay, let's do one more. Let's see. By the way, the documentary is on Hulu.
Sorry, I was going to say, all these people asking, I guess we didn't say that. It's a 3-parter documentary about the Delphi murders, and it's going to be on Hulu. And just so you guys a little bit of tidbit background, we had no idea what we were doing because they were so secretive about it. They were like, can you meet at this abandoned house?
Yeah, basically.
They literally were like, can you come? And we're like, to where?
They called us and they were like, what do you think about this case? And we gave them the whole spiel. We're like, well, here's, there's no conspiracy. He obviously did it. Here's all the reasons he did it. And like, this is like everything. And they're like, great. That's exactly what we want. Like, meet us somewhere. And
it really was. It was like a haunted house. They're like, meet at this haunted house, not close to your home. And we showed up. And when we showed up, they were like, do you have any questions? And we were like, what's this for?
Yeah, like,
it shows you how trusting we are.
And they're like,
we
we're with ABC News.
And we're like, so this is like a thing. And I was like, I don't know. I thought maybe this was some weird guy's pet project. He just had like a camcorder and he was going to, set it up and have us talk.
So it's called Capturing Their Killer, the Girls on the High Bridge. So
note that Delphi is not in the title. So I mean, if you searched Delphi, it might come up. But there are other Delphi documentaries, and it's not the other ones.
Okay. This person says this is HC Taylor HC. And they want to know, how would one become besties with Brett? I figure Alice can probably give me the most insight, but I'd appreciate both perspectives so I can get to work right away. Notice they don't want to be besties with you, Alice.
Nobody wants to be besties with me. You send him a lot of alcohol.
Yeah, you nailed it.
That's all you do, guys. It doesn't take a ton of thought to know that that's exactly the way to his heart is just free alcohol. So you can buy him a drink at the bar. You can mail it to him, which is illegal, so don't do that. You could show up at CrimeCon and hand him some alcohol. Olive oil. That's how you become besties with him. How did we become? I mean, we did not start out besties.
Yeah.
Because that's weird to like meet someone and be like, we're besties now.
You worked for me and you were awesome.
I did work for you.
So it worked out.
That's true.
And
then you worked for me.
Exactly. It's like, so just, how the tables have turned. And I just want to say right now, I'm drinking Cinder and Smoke, which Cammie gave to me at the last CrimeCon. And I've only got a little bit more left. So hopefully those of you who are going to CrimeCon will bring me a little bit more.
You see? Easy, and it works. It does.
But
no, we did not start out as besties at all. We barely started out as friends because that was a real intense way to like start any sort of a friendship.
You were always my favorite person.
Stop it.
It's true. You're like a ray of sunshine. I've said this before. Like, I'd be walking down the hall like, and I'd see you coming, always walking really fast because you're always walking really fast with this huge smile on your face, and I'm like, there we go. Feel better now. So
I probably was delirious because we didn't sleep for like the entirety of that project, which was months long. I think it was the project, 1 month, but it felt.
Project comes to an end. And I go in and I'm like, Alice, I have loved working with you. I think you should stay. And Alice is like, nope. Sorry. Got other opportunities. I'm out.
That's literally what I said.
Yep.
No, thank you.
Yep. She gave that radiant smile that she always has. And she's like, No.
Yeah. And then we basically didn't hang out after that because I was like on another floor.
I was insulted.
You were not insulted. I was utterly on a different floor.
You were.
I volunteered to help you on some of your work for free. See, I volunteered.
I asked you to stay, and you're like, no, I'm going to go be your boss. And that's what happened.
I did say that.
Like, you then
I did do that. Like, oh, well, I did do that. I forgot about that.
Okay.
Now that you put it that way, that is exactly what happened.
Yeah. But then the next project, I pulled you back down from your high station.
And then you left.
And then I left.
And then you left. You made me do all the grunt work, and then you left.
It's true. And you did do the grunt work. Yeah.
So, wait, was that the second project we worked on?
No, and we went to the archives together, remember?
We sat in the dungeon together.
Yeah, we sure did.
Records
we should
that
have
don't
been
exist.
looking for the orangutan stuff. But instead
That's right. I forgot we sat in that. There was like no air in there. They were like,
Yeah.
no one ever visits us down here. What are you doing?
I know. It was seriously like, hello.
Hello.
Living people.
Can I help you find anything? We're like, I don't know. Can you? And then they sent us to the other archives, and we're like, there's a more secret archives. It was like in the dungeon, and you had to like do this thing with the bookcases because they like, came down.
Yeah, and move them.
Yeah, you had to,
Yeah.
like move the bookcases. Oh, that was a lot of fun. Well, what I was gonna say is the second project we worked on, it came to an end when my oldest turned 1. So my first birthday party for him was also a celebration party. It was like all these lawyers at a 1-year-old's birthday party drinking heavily. It was a morning party too.
Do you remember that time that I called you at like 8 o'clock at night and I was like, hey, talk to one of the most important people in the country and explain that thing you just explained to me and put you on speakerphone?
Yes.
And then you explained it and you did a
Yeah.
great job.
Oh, thanks.
And then I hung up with you and they were like, so who was that? I was like, that was Alice. And
She should be your boss.
she is awesome. So
I do.
Yeah.
I remember that because you were in a park or something.
who knows?
And I remember thinking, I trust you so much that I'm about to divulge like state secrets into the void, and I don't know
Right.
who I'm speaking to.
Yeah. Yeah. But it all worked out. So here we are.
And then, years later, we're doing a podcast.
We're doing a podcast
We're
together.
doing a
Right.
podcast.
Who would have ever thought?
I literally would have never thought.
Would have.
Oh my gosh, we
Ever.
never signed off. We should.
No, we're still going. We're
still
answering questions. What are you talking
Oh,
about?
we are answering questions.
Yeah.
Okay, so bottom line, give him lots of alcohol. But the
Sure.
other thing you should do too, like if you really want to be besties, is when you give him bourbon, you also give him a pack of gummy worms, the sour kind.
The number of times that I've been trying to do like keto, and Alice and I go to a gas station. Alice like, let's
It's
get
always-
some gummy
always the
worms,
gas
and I'm like,
station.
I don't know, I'm kind of doing this no sugar. No, let's do some gummy worms. And then she gets the gummy worms, we eat the gummy worms, and she's like, oh, wait, you were doing keto, weren't you? And I was like, yeah, but it's fine. I'm 500 grams of sugar into this now. It's cool.
I've done that so many times to you.
It's true. It's true.
I'm like, we'll split a bag. It's fine.
It's fine. It's fine. It'll be great. We'll split it together.
I'm a really bad enabler. I'm sorry.
The other thing, bring me a mystery. I love mysteries. If you have a mystery, a new mystery I haven't heard before, that's not a way to be my best.
The other thing is come and talk about one of his books to him.
Oh, yeah. Absolutely.
Right.
That'll do it.
Yeah.
That'll do it. Yep.
There you go. That is the secret to all. The harder part is how to become a trusted colleague of mine.
I got to say, this episode, for those of you listening when this released, you missed the beginning because you're not a patron. So maybe
You're not
you
a
should be a patron.
Premium patron.
You're not a premium patron. And so this episode started crazy and it's ended crazy. And I think that's the best way, right?
It's the
What more
only
can you
way.
say?
It's the only way, indeed. Well, guys, this has been incredibly fun. I hope you've enjoyed talking about all the legal nerd stuff. We obviously love it. We love hearing from you. As we've always said, when you see the rest of the true crime media losing their minds about something, most likely it's actually not the end of the world, as we've explained in this case. But you're going to hear a million more of these. It's the end of the world in every single case to the end of time. So hopefully we've been able to shed a little bit of light on civics. And you can now go forth and educate everyone else. So don't do the clickbait, dig in, read the awesome opinions, join us, and read these opinions for yourself. You can write to us at prosecutorspod@gmail.com. Let us know what you think and let us know what else you want us to cover. But until next time, I'm Alice,
And I'm Brett.
and this is the Prosecutor's Legal Briefs. And so he draws all the time. He's very good at drawing. I'm terrible at drawing. Don't know where this amazing talent comes from. So he's like, freehanding all these different sea animals. And he's like, well, look at this octopus that I drew. And I looked at it and I was like, that's a really good octopus. Like, how did you learn how to draw an octopus? He goes, I look at pictures of cephalopods all the time. And then he went back to drawing. I was like, nobody else is here to laugh with me. Not a single person. Just
love
me.
cephalopods.
He is the most unintentionally funny person I know. Whereas
Just when you thought summer couldn't get any hotter, Pluto TV is turning up the heat with thousands of free movies. Presenting Summer of Cinema. Stream your favorite blockbuster films like Gladiator,
I will have my vengeance.
Good Burger,
This is what I call fast food!
Beverly Hills Cop, The Girl with a Dragon Tattoo, and Julie and Julia.
Bon appetit!
All for free on your favorite devices. Pluto TV. Stream now. Pay never.
Whether we're catching flights or catching sunsets, staying hydrated is a non-negotiable.
Fiji water is always in our carry-on. It's really from the islands of Fiji, and you can taste the difference.
That soft, smooth sip, it's the electrolytes for me. More than double compared to other premium waters.
And the 500 milliliter bottles, 100% recycled plastic since 2022. We love a travel companion that gives back.
For your next trip, layover, or beach escape, pack Earth's finest water.
Fiji water. Hydration, but make it luxe.